Attorney General for Bermuda, Appellant, and Ferguson and others, Respondents, Bermuda.
This is an appeal from Bermuda, where the question of the legal recognition of same-sex marriage has generated a divisive controversy. The Domestic Partnership Act of 2018, which I'll call the DPA, sought to resolve the controversy by creating a new legal relationship, the domestic partnership, as a means of giving legal recognition to the committed union of two people of the same sex. Section 53 of the DPA confines the institution of marriage to the union between a man and a woman. The point in issue on this appeal is whether the Constitution of Bermuda invalidates Section 53 of the DPA. The respondents in this appeal, who are a gay Bermudian, a lesbian Bermudian, a Bermudian LGBTQ charity, and 3 Bermudians associated with 2 churches in Bermuda, began legal proceedings claiming that Section 53 of the DPA was invalidated by the Constitution. They advanced 3 grounds for their challenge. The first ground was that that provision in the DPA was enacted primarily or mainly for a religious purpose, contrary to the secular nature of the Constitution. The second ground was that Section 53 of the DPA hindered their enjoyment of their belief in same-sex marriage as an institution recognized by law, and thus was contrary to Section 8 of the Constitution, which protected freedom of conscience, thought, and religion. The third ground was that the provision was in breach of Section 12 of the Constitution because it affords different treatment to the respondents and others attributable to their description by creed. The respondent's claim was successful at first instance before the Chief Justice on the ground of freedom of conscience, which is Section 8 of the Constitution, and on the ground of unjustified discrimination attributable to the respondent's belief in the legal recognition of same-sex marriage. The Court of Appeal dismissed the Attorney General's appeal and upheld the respondent's challenge on 2 grounds. Those grounds were that Section 53 had been enacted for a religious purpose and that the challenge under Section 8 of the Constitution, which the Chief Justice had upheld, also succeeded. The Court disagreed with the Chief Justice on Section 12 of the Constitution, holding that that provision gave protection against discrimination, which was attributable to a creed involving a system of beliefs and not a single belief, such as the belief in same-sex marriage recognized by law. The Attorney General now appeals to the Judicial Committee. The Judicial Committee, by majority, would allow the appeal and advise Her Majesty the Queen to that effect. Lord Sales dissents and would have dismissed the appeal, but only on the ground that Section 53 was in breach of the protection of freedom of conscience in Section 8 of the Constitution. The Board is unanimous in rejecting the respondent's challenge based on an asserted prohibition of legislation enacted for a religious purpose. There is no such prohibition in the Constitution, nor has the Board recognized such a provision in other constitutions within its jurisdiction. Constitutional validity is assessed by the effect of the legislation and not the motivation of the legislators in enacting it. In any event, the Board is satisfied that the DPA, including Section 53, was not passed for a religious purpose, but as a compromise between different opinions in Bermuda and to fulfill an electoral promise. Similarly, the Board is unanimous in rejecting the respondent's challenge under Section 12 of the Constitution. That section prohibits discrimination against people that is attributable to their description by their creed, and not because they hold a particular belief. In any event, the exclusion of same-sex couples from marriage is attributable to their being of the same sex and not to their or their supporters' description by creed. It is in relation to the Section 8 challenge, that is the freedom of conscience challenge, that the board is divided in its view. The majority, Lord Reid, Lady Arden, Dame Victoria Sharp, and I, while recognising the profound significance of marriage and the historical background of the denigration and victimisation of gay people, hold that Section 8 does not impose on the state an obligation to give legal recognition to same-sex marriage. This is because Section 8 prohibits the state from hindering the enjoyment of freedom of conscience, including the manifestation of a person's thoughts and beliefs. Drawing on the jurisprudence of the European Convention on Human Rights, which has had a profound influence on the Bermudian Constitution, the majority identify two ways of analysing the matter. The first approach is the view that the belief is within the ambit of and is protected by Section 8, but that Section 53 doesn't prevent the respondents from holding, manifesting, and arguing in support of their belief that the law should recognise same-sex marriage. Nor does the legislation prevent ministers of religion from recognising such marriages as a matter of religious practice. The second line of reasoning, which is also derived from that jurisprudence, is that the belief in the legal recognition of marriage is not within the scope of Section 8 in the first place. Lord Sales, in his dissenting opinion, considers that the respondents' beliefs are protected and that protection extends to an obligation on the state to give legal recognition to same-sex marriage. The belief, he holds, is a conscientiously held belief as to how they should live, involving a moral obligation to enter into marriage with their partner. The state has a duty of neutrality as between different conscientious beliefs, and a range of courts around the world have concluded that same-sex couples have a fundamental right to marry equivalent to that of opposite-sex couples. Section 8, in his view, entitles same-sex couples to have their committed relationships given legal recognition as marriage, and that the right to marry is implicit in the Constitution as an aspect of Section 8.